In today's video, we're going to talk about 3 debt collector lawsuits where debt collectors just seem like they were just going to steamroll over people, violate their rights, and I believe that they mainly do this type of stuff because people don't have the resources to fight back, or they don't know their rights. Because you can actually fight back against debt collectors without hiring an attorney if you know exactly what you're going to be fighting back against. It's not about having to go in there like you're an attorney. It's just to understand your rights, what you can question them on, what they have to prove. And I'm going to talk about 3 cases. Well, three, I'm not going to mention the cases. You'll be able to look them up. But 3 debt collector cases that you will be shocked when I tell you what they actually tried to do and the way that they tried to weasel their way out of it. And then, I'm going to talk about the solutions, what you can do to help yourself if you find yourself being either having a debt collector contact you over and over again about an old debt that they've purchased, or if you have a debt collector trying to sue you in court. Because I understand, see, this is the thing in why I make these videos, why I try to relate to you while you're watching, is because I understand how you might be feeling. I understand that you might have low confidence, you might be struggling financially, you might have low self-esteem, because those are the things that I experienced when I was going through my credit and debt issues. And so I know how you are probably feeling. And I also know that a lot of you, when you are watching videos, you're looking at solutions, you want it to, you want it fast. You want it fast. You want to have a solution that can work right away. And you need to understand that it is a process. And when I go over these 3 here, you will really understand that it is a process, that it could truly take some time. Because when I tell you what happened in these cases, you're going to be like, well, man, this is like straightforward stuff. And how did it even extend to get to as far as it had to get? So before I get started, in case you don't know, my name is Stephen A. Williams. I'm the president and founder of the creditrepairshop.com. We've been helping our clients repair their credit, increase their scores, and deal with debt collectors since 2006. Everything that I tell you in my videos, I've either experienced myself when I went through credit and debt issues, getting out of $300,000 in debt from 1994 to 1999, or from what I've experienced with helping my clients. I run a full operation, full-time employees. It is not like a one-man show. All right, so let's get to it. Here's the first case that I want to talk about. And this case actually went to the U.S. Court of Appeals for the First Circuit. A debt collector continued collection efforts against an individual who had declared bankruptcy. So if you know the rules, once you declare bankruptcy, debt collectors and creditors, unsecured creditors, and even creditors that do have secured property, like that you have a vehicle or a house, they have to just stop where they're at and see if you're going to reclaim those items and continue paying on them. Well, this debt collector here continued the process, even though the individual declared bankruptcy. That is a violation of bankruptcy laws. Debt collectors falsely claim that the person could be sued if they didn't pay the debt, even though they had declared bankruptcy. The court emphasized that even if the debt collector claims ignorance of the false statement, they could still be held liable under the Fair Debt Collections Practices Act. if they didn't have effective procedures in place to prevent such mistakes. This was U.S. Court of Appeals for the First Circuit, Consumer Financial Protection Bureau brought that suit. Here's the second one. Second one. Medical debt collection violation. We deal with a lot of these. I can tell you straight off the bat, here's a solution that usually works the first time if you do it right. If you have medical debt collections coming at you, it is a HIPAA violation to show your procedures. Some of your procedures will be shown with the bill. Like, I can give you an example of one is the let's say that you have the what is the one where they look for cancer inside of you? I forgot the gastric surgery, or not gastric surgery, but I don't know what it is. But where any procedures, just say any procedure, it doesn't matter how bad or how minimal it is, no one is allowed to see any medical procedures that you have without your written permission. And so there was a violation here, medical debt collection violation. There has been numerous FDCPA violations related to collections of medical debt. Debt collectors must verify disputed debts before resuming collection efforts. So they're basing this one just solely based on the debt collection company did not do their due diligence on making sure that the individual owed that debt. So things that you need to watch out for with medical debt. Were the bills supposed to be paid by the insurance company? Are these deductibles? Were they verified through the medical provider if these items were supposed to be paid by the insurance? Some of the times they separate, like you go to one medical provider, but they have all these different departments from outside vendors. And this is even in the big hospitals. It happened to my wife. They had someone come in to do a procedure when she was having her surgery, and the billing went, that vendor billed us, and it was something like $7,000. That was supposed to be paid by the insurance. When we did that verification, it showed that it was supposed to be sent to the medical provider to be paid from the insurance, because the medical provider got the entire payment and they were supposed to pay their vendors. So those types of mistakes happen, but that's billing. You need to watch out for that, because that happens a lot with medical bills. But the other part of it is that any debt collection company that is suing you or coming after you for medical debt, they are not allowed to know any procedures that you had. And it's very difficult for them to have documents, receipts, proof, anything from a medical provider that won't show what procedures you've had. When we've sent out a letter specifically stating that, every debt collector sends it back to the medical provider. But you have to do it right, because what you got to do, just like how in the previous one that I just mentioned, where the debt collector pretended like they made a mistake. The reason why they're able to pretend like they made a mistake is because the individual didn't make it clear to them, nothing in writing to them, nothing certified that they received that they were in bankruptcy. Same here for medical providers. For medical debt collectors. If they have access to your medical records and you send them a debt validation letter talking about how they came up with that number, you want that verified, that it could potentially should have been paid by insurance, and show me how you got access to my private medical data. Show me my signature, giving you authorization to see the medical procedures that I've had done to me by my medical provider. It will go back. If you do that the right way, it will go back. They'll be like, you got to deal with this one. the hospital got to deal with it, and then their people will call you, and you can work out a deal with them. The third one here was CFPB, and this one was enforcement. Actively holding debt collectors accountable for misrepresentation and unfair practices. For instance, they recently secured a ban against certain debt collectors in the industry for targeting vulnerable groups like small businesses and nonprofits and enforcing small claims on debt. For small businesses, let me tell you the ones that I've seen that are very prevalent against small businesses. These credit card lending companies, they come after small businesses like a hawk. If you get stuck with these daily, where you're paying these off of your credit card merchant account loans, these companies will scavenge your business. They come after you like the mafia if you don't end up being able to pay that payment on a daily basis. They want their payment daily. And then also these small business fintech, quote unquote fintech companies, where they're offering out small business loans, and you just got to be in business for 1 year and have gross income of like $1,000 of $20,000 or more. I'm telling you, these companies, you want to shy away from them, in my opinion. I mean, that's just my opinion, because what it seems to be is that these companies trap you. And then once the debt collector gets their hands on it, they are utilizing, and it says it right here with the CFPB, that they're utilizing debt collection tactics that are misrepresentations and unfair to the business owners, nonprofits also, and then also with individuals. They put a lot of pressure on people, a lot of pressure to try to get people to pay when they're not in the position to pay, and they don't tell them their rights, that they have a right to express a hardship, and that they can work out something, or they can keep the communications open and hold off for a little bit just to buy a little bit of time. So let's talk about some of the cases. So false statements and bankruptcy misrepresentation. The case was Corrales. I can't even pronounce this name. It was against CICA Collection Agency, and it's Corresculio. I think that's how you say the name. First Circuit. An individual who had filed bankruptcy received a collection letter from CICI Collection Agency stating that they could be sued if they didn't pay the debt. The statement was false due to the automatic stay protection under bankruptcy law, which prohibited such collection actions. Remember what I said earlier. When you file bankruptcy, everything has to stop. They can't move forward with anything. The outcome, the Consumer Financial Protection Bureau filed an amicus brief supporting the consumer, arguing that debt collectors cannot escape liability by claiming ignorance of a false statement. The court emphasized that effective procedures must be in place to prevent such errors, and upheld the interpretation that even unintentional false statements can result in liability under the Fair Debt Collection Practices Act. So in short, they can't send a debt collection letter knowing that a person is in bankruptcy. And it is, remember what I said. Here's another one of those validation statements. Remember what I said in another video. I said that these attorneys do not review these debt collection letters. They don't review these files. And that one of the number one things that I've told people to do, and that what we do with our company, is to request that an attorney has reviewed the file. Because if an attorney reviewed the file, the attorney is going to look at all of this stuff, because they're going to have to sign off on this. They're going to have to sign off one of the check marks. Has this individual filed bankruptcy? Do we have all of the information to prove in court, if it ends up going there, that this individual is the right individual and that they have to pay this debt. But they don't do that. They just send those letters out, and this shows you proof right here. For medical debt violations, it says here, right here, widespread violations of medical debt collection. The National Consumer Law Center, NCLC, reported numerous instances where debt collectors failed to verify medical debts before resuming collection activities, which is required under 15 U.S.C. 1692GB under the Fair Debt Collection Practices Act. For example, consumer disputed medical debt, but the collector continued collection efforts without obtaining proper verification. Also, outcome: consumers successfully brought claims under the Fair Debt Collection Practices Act against debt collectors who did not report the debt as disputed on the consumer's credit reporting agency. So remember what I said earlier, that this is a process. Credit repair is a process, and it states right here, even though consumers were disputing it, even directly with the furnisher, the debt collection company, they did not notify the credit reporting agencies that these accounts were under dispute, and they continued with their debt collection practices. So they were sued for that. These violations not only pause collection activities, but also potentially result in damages awarded to the consumer. Okay, let's go with the next one, which was phantom debt collections and false claims. The CFPB and the Federal Trade Commission, FTC, have been involved in multiple enforcement actions against debt collectors making false claims. Now, it says here, one notable case involved the FTC securing a ban against a debt collector for making false representations to consumers. The collector falsely claimed that the consumers owed debt that they did not actually owe, often related to phantom debt or inflated amounts. Here's another validation of what I said. Now, I don't run into too many phantom debts. I know that that's a problem that's out there, but I do run into this inflated debt amount. You always have the right to see how they came up with that amount, and that you're requesting verification, balances, credits, payments, interest rates, everything that would show how that amount was accumulated. They can't just walk up to you and say you owe this amount. You have a right to come back at them and say, show me all the documentation that prove how you came up with that amount. A lot of people say, show me the documentation of that I owe you for the debt, and then they're going to try to give you, the bill of sale that they got from purchasing the debt from the original creditor. But that never has how they came up with that amount that they claim that you owe. So the outcome from the enforcement was the enforcement action resulted in permanent ban from the industry for the involving parties and monetary compensation for the affected consumers. For instance, in a recent case led to the return of more than $1 million to consumers harmed by phantom debt collection schemes. So, in short, when putting together your response letters to any debt collectors who are trying to sue you, who are trying to collect from you, this is before they try to sue you, but it helps you if they decide to try to go to sue you, because you're going to have certain documentation showing that, number one, you were interacting with them, so they should have put that on your credit reports, and if they didn't do that, that's a violation. But also making them prove how they came up with that amount. You're going to have proof in your hands if they either responded with limited documents or if they never responded at all, because you're going to have proof that you did try communicating with them. All right, if you need help with your credit, please visit us at thecreditrepairshop.com. Watch this video, What Makes Us Different, so you can see my 8-point validation process, my 2-phase settlement process. If you need your credit reports and scores, go to the website your3scores.com to grab your TransUnion, Equifax, Experian credit reports and all 3 scores. If you have debt collectors coming after you, grab my 3-pack of letters. statute of limitations letter, debt validation letter, and cease and desist collection activities letter. And use the one that's appropriate for your specific situation. If you have debt collectors trying to sue you in court, there's links below this video also. All the links are below or above this video for you if you need any of the services. Please subscribe to the channel, post your questions and comments. This is Stephen A. Williams, president and founder of thecreditrepairshop.com.